All right, we are officially live on YouTube. So I have 5 o'clock on the clock for me. So with that, let's go ahead and make a start. Um, Good afternoon, everyone, and welcome to Family Law Now After Hours. Today's topic is how will divorce affect my pension? And this is a practical session that is designed to help you understand how pensions are valued, divided, and protected during separation or divorce. Me and my colleagues today will be breaking down complex concepts into a clear, actionable insight so that you can plan for your financial future with confidence. That's the key, planning with confidence. If you are joining us today via Zoom, you can go ahead and use the Q&A feature to submit your general comments or questions about this topic. For those that are on YouTube today, unfortunately, you won't have access to this feature. But for those, again, on Zoom joining us, go ahead, please submit your questions. We appreciate them. They help guide the conversation. But for specific questions about the details of your family law matter, please contact our team directly. So we will only be answering general questions, nothing specific today. And the purpose of the series is to discuss general information on separation, divorce, and other family law matters. And any information provided here today should not be construed as legal advice to you. As well, please stay tuned until the end as we will be sharing how you can schedule a free initial consultation with one of our lawyers here at Russell Alexander. Now I'm going to introduce our panelists for today. You will see on your screen Mark Simpson. He is an associate lawyer here at the firm, and he guides clients through family law with solutions that save time and resources. He previously ran his own practice, gaining experience in trials, mediations, and arbitrations, and now serves as principal to the firm's articling student, Jen. Mark is a father of three teenage boys, has coached two baseball teams over the past 3 years, and enjoys mentoring. Excuse me. He has also served on the Hamilton Road Business Improvement Association board, and outside of work, he serves on the Middlesex Law Association and Oak Ridge Optimist baseball boards and pursues his passion for health and fitness. Bill Rogers on your screen is a managing associate lawyer here at the firm, and his courtroom experience includes numerous motions, several full-blown trials, and he has also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014, McConnell and Huxtable, which prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. When he's not practicing law, he loves spending time playing music with his band Soul Custody. And myself, I am a compassionate family lawyer driven by a deep desire to support families through challenging times. With a background in commerce, I bring strong negotiation, analytical, and critical thinking skills to my legal practice. During my articling period, I gained confidence in handling a wide range of family law matters, and I emphasize active listening, clear communication, and empathy, fostering a comfortable environment for clients. I am certified as a collaborative lawyer with the Ontario Association of Collaborative Professionals, and thus I offer clients an alternative dispute resolution approach to avoid court. Outside of work, I am a dedicated Toronto Maple Leafs and LA Rams fan and enjoy playing hockey and watching comedy movies. And with that, let's get into our conversation for today. So, pensions, what are they and how do they interact with the laws surrounding the family, matrimonial, and ultimately divorce? So, pensions matter in separation. That's just the bottom line here. And for many people, their pension is the second largest asset after the home. And in some cases, it's even bigger than the house, especially if it's rented. And because pensions are often seen as something far off in the future, people really truly underestimate their importance. But under Ontario family law, they are treated like any other asset that has value today. And failing to deal with pensions properly can result in a very unfair property settlement. So the legal framework in Ontario that we use in relation to determining how pensions are divided and equalized is governed by both the Family Law Act and the Pension Benefits Act. And the Family Law Act uses the equalization of net family property system, which means that each spouse lists their assets and debts at the date of marriage and again at the date of separation. And the difference between the two is their net family property. And whoever has the higher increase owes the other spouse half of the difference. And pensions are considered property under this system, right? So the value that is accumulated during the marriage is included for the purposes of these calculations. In relation to how pensions actually fit into this equalization process as a whole, a spouse doesn't automatically get half the pension itself. That's very important and often a common misconception. Instead, the pension's value is added into the calculation with all other assets and debts. So, for example, just on a broad scope here, if one spouse has a pension worth $200,000, and that's what's accumulated during the course of the marriage, so again, from date of marriage to date of separation, and the other spouse has no pension, that $200,000 pension becomes part of the equalization payment calculation. It doesn't automatically mean that the other spouse is entitled to $100,000. And in some cases, the result is either a direct pension division, which would be the transfer of funds. And in other cases, it is sometimes offset against other assets, such as the home or RSPs. And as always, as we practice and how the legislation was framework was developed, it deals with the principle of fairness. And the law recognizes that while one spouse may have been working and building pension credits, the other may have been contributing to the family in non-financial ways, right? So, for example, childcare, homemaking, or supporting the working spouse's career. And equalization is meant to ensure that both parties leave the marriage with an equitable share of the financial gains. Not equal, but equitable share. And with respects to settlement itself, if spouses can agree on pension division, they can do so in a separation agreement. But if not, the court will rely on the official pension valuation provided by the administrator. In some cases, it'll need to be done through an actuary, but more often than not, it's done through the pension plan administrator. And as it goes with most family law cases, negotiation can allow for more flexibility. For example, maybe one spouse keeps the pension while the other gets more of the home equity. There's ways to work around negotiated settlements. And with that, I am going to, unless Mark or Bill want to add anything to that, I think it'd be a good segue into Bill discussing the types of pensions that are present and that we often deal with on a day-to-day basis.
Yeah, thanks, Joe. And j just to clarify, if you're not married, none of what Joe says applies to you. Um, well, it kind of does, but it's an indirect way. You have to make what they call a trust claim. Same basic idea, but it's not a mathematical formula. It's kind of foggy and it's sort of what's fair. So, just to keep that in mind, only married people get equalization in the province of Ontario. Now, in terms of different kinds of pensions, there's two kinds of pensions. There's a defined benefit, and that's kind of what we're talking about. That's what most of them are. And then there's something called a defined contribution pension, and we don't deal with that a lot. And if we do, you don't really need an actuary to determine the family law value of something like that. It's kind of like an RSP. So the value of a defined contribution pension, you can find out for the latest statement. Uh, like you get a statement for your RSP every month. You usually get a monthly statement, or every 6 months you get a statement for your defined contribution pension, and that gives you the value. So it's pretty straightforward. But most of the pensions we deal with, the way Joe was talking about, are called defined benefit. So regardless of what you contribute, there's a benefit for you when you retire that's guaranteed. And that's what you get when you work for, a company or uh, um, usually it's some sort of a big company will have that, and that's where that kind of a pension comes in. And like you said, Joe, the way what you do is I look at it like a piece of real estate, but instead of getting a real estate appraiser to value it on the date of marriage and then the date of separation. You'd get an actuary, which is usually the pension administrator, right, Joe? I think they are actuaries, most of them, or they have access to it, and they'll do the value for you. So
Mhm.
think of it as a piece of real estate that has a value, and it goes into your calculation.
Exactly. Mark, did you wanna add anything to that? Or maybe you want to touch on anything I've previously said so far?
Um, my observation is pensions also encompass or can include federally regulated pensions, whether that's a private, federally private pension plan, federally regulated, such as Air Canada, or a federal public sector federally regulated plan, such as our CMP or Canadian Armed Forces.
And
Yes,
they're kind of
100%.
valued the same way. Like I think you have to get different people to do it, but it's the same concept. Like
Yes,
what an actuary will do will say, well, what's your life expectancy? What are the chances of this? It's kind of what they do.
yes. The um, its rule of thumb is to still look for the value from the uh, federal pension administrator on the Ontario
Yep.
Financial Services of Commission of Ontario
Yeah,
Statement of Family Law Value. If
exactly.
if the pension is being entered, if the $200,000 pension is being entered into the net family property statement for purposes of treating it as a real estate piece to determine the equalization payment.
Yep.
If spouses, one of them has a federally regulated pension and they elect to divide the federal pension pursuant to the federal legislation, should still obtain the value, but that's where the role of experts becomes
Yep.
critical to get guidance on basically
And
flipping
it's
over
it's
into the federal regime
yeah.
for the
It's amazing
division.
how much these things are worth. Like we're talking, it can easily be millions of dollars if you've been working somewhere for a long time.
Yes.
Yeah.
100%. And I think that the big question that everyone is wondering, more so our viewers today, is how pensions are actually valued. I think that's the crux of our discussion today. And first, I'm sort of want to discuss why valuation is necessary. Um, and the reason for that is because a pension is not like a bank account where you can simply look at the balance. Again, of course, if in relation to Bill's comment with respect to the defined contribution. Again, I'm more so focused on the defined benefit type pensions, whereas it's a lot more common, and that's more often, I would say about 90% of the pensions that we deal with are a defined benefit. But it represents future income. And that's again sometimes decades into the future. So it must be translated into today's dollar value. And the idea that we look at is if we had to buy this pension today, what would it be worth? Right. So I know we discussed briefly about who actually does the valuation. And in Ontario, this is a streamlined process. So the pension plan administrator, for example, whether it's OMERS, Hoop, teacher's pension plan, if it's another private employer plan, they must calculate the value if it's requested by the pensioner. So again, our family law client, and the spouse, lawyer, or financial professional. What they'll do is they'll submit a request form with proof of marriage date and separation date. A fee is paid, and usually it's about a few $100s, depends. And the administrator then issues what's called a statement of family law value. And this is the document the court and the lawyers rely on in terms of determining what the equalization payment in relation to that pension should be. And the family law value includes the total value accrued during the marriage. So again, this is the number that's used for equalization purposes. It'll also include what's called a pre-marriage service value. So that is excluded from division, but it's calculated for clarity. And I should mention these family law pension valuations are extremely in-depth, and the amount of forms and documents you get from them is quite extensive. But again, most people are more just concerned with the total value accrued during the marriage, which makes sense. You also would likely receive what's called the post-separation service value. Again, that is excluded as it belongs solely to the pension holder. Again, when we're looking at equalization, it's from date of marriage to date of separation. So anything before or after that is not used for the purposes of equalization. And what it also includes is a clear breakdown so that there's no confusion or double counting. So that's really important as well. And of course, there's always special circumstances. So if the pension is already in pay, so that means that, likely the spouse is retired, the administrator calculates the commuted value of future payments, right? That's also important to take into consideration. And if the plan is a federal pension, as Mark mentioned, whether it's military, RCMP, federal public service, employee. There are separate rules under federal legislation, but again, as Mark mentioned, the same principles apply. Um, and there are some private or foreign pensions that would actually require actuaries to step in if it's not covered by Ontario's system. So again, just because a pension is not stemmed from Canada, it does not, again, whether it's provincially or if it's a federally regulated pension plan, that does not mean that it is not included for purposes of equalization. All assets, whether nationally held or internationally held, so foreign assets must be included for the purposes of disclosure, and so that equalization can be determined appropriately. And
We
the
we've
big
we've we've faced
go ahead,
that.
Mark.
Sorry, we
No, go
faced
ahead,
that
please.
uh, quite often, where a spouse or the pension member who is employed for a national-wide company. Spouses may reside in Ontario. The head office and a pension administrator of said company could be in BC, Alberta, another province. And the questions arise in terms of the steps to take to value that pension as well.
No, 100%. And I mean, again, that just goes back to why accuracy is so critical. And, without the family law value, parties could end up negotiating based on guesses or outdated statements. I always like to use this example. Maybe a spouse might assume their pension is worth $50,000 because that's the contributions they see on their statement. For example, if it's a defined contribution, or even if it's a defined benefit and that's what they see on their pay stub, X number of dollars going towards the pension contribution. But the actual family law value may be 200,000 once future benefits are considered. And courts will not finalize equalization without the official family law value of these pensions. So, unless either Mark or Bill want to expand on anything that I've mentioned, I'd like to actually switch it over to Bill just to give more of a deep dive as to how the actual division of the pension benefits is undertaken.
Just the observation that we, the family law lawyers, can assist on guiding the client in the right direction. I'm sure this sounds quite complicated.
Yeah.
It's complex for us. We
Yeah,
can guide you
we'll
in the
look
right.
after all this stuff. It's complicated, but just to underscore what Joe said, um, the value of a pension is what accumulates between the date of marriage and the date of separation. So when you're applying to get the family law value, um, to whatever administrator is the correct one to do, and there's a form, and the fee is, what is it now, 800 bucks, or is it
Six
less?
Six-
eighty.
600, I believe, if it's
600.
a
Okay.
benefit.
Anyway, and usually people, well, whoever has the pension normally is responsible to pay that, but um, uh, it's not uncommon for people who are divorcing married people to disagree on the exact date of separation, um, because it can have a financial consequence. Um, the simplest example is if you're married and you know you you separate and then a week later you come into a bunch of money from some source. That money is off the table because you did not get it during the marriage. So your ex is going to say, well, wait a second, we were still together for weeks after that. And it's a bit of a gray area there as to what the exact moment is when the relationship was over. But so that does happen. And more than one occasion, I don't know if Mark and Joe have had this too, but you end up, um, one person has one date of separation that they're arguing for, and the other person has a different date. So what you end up doing is you have to ask the pension administrator to give you two family law values, one for each date. And you can do that. And they charge double, I believe. And then you've got two statements. Um, so that's one of the things that does occur. And like Mark said, your lawyer will take care of it all. Don't worry about it. Just feel fortunate you have a pension because a lot of people don't. Anyway, so that's how you value it, and it goes into this equalization calculation that married people have, and I'm oversimplifying it. There's basically two ways of equalizing your pension. One is if you can afford it, you can pay cash that you got from someplace else, to your ex and leave the pension intact. Or uh, if you don't have, a lot of people can't afford that, so they'll divide the pension at source. If it's not in pay, they can actually dip into the pension fund and transfer a lump sum to your ex. And it goes into something called, they don't give them cash. It goes into a thing called a LIRA, locked in retirement account, so they can't touch it until they retire. So you can do it that way. Or if the pension holder is already retired on data separation, then the pension is what they say is in pay. That happens. Um, you can also divide it at source every month. It's not a lump sum. It's like the monthly check gets divided. Or if you have enough money, you can pay cash checks and then leave your monthly check intact. It's not going to get cut in half. So that's kind of I'm oversimplifying it, but those are the two basic concepts. Does that make sense, fellows, before I move on to survivor benefits?
Yes.
Yeah, I think you covered it completely. It's either you have enough liquidity
Yeah,
to be
yeah,
able
yeah.
to
A
pay
lot of
out.
people can't afford it, you
Yeah,
know,
100%.
like because some of these, the amount of cash you'd have to pay is a lot. Some of these pensions are worth a ton. And it's
Yeah,
not like Joe said, it's not the statement you get from your employer that says, here's your pension statement. You know, people have those and they think, oh, this is the family law value. No, that's not it. Family law value's got to be done by an actuary. It's going to be way more, and you got to fill out the forms and pay, and then you get it.
Mhm.
Now, there's something called a survivor benefit. If the pension holder is retired on the date of separation, which happens, it's not uncommon, um, then the family law value that you get from the administrator, it'll say right on it, the pension holder is retired, the pension is in pay. And then it spits out a second number. It gives you, number one, it gives you the family law value of the pension. Um, let's say it's 1.5 million, just arbitrarily assume that. And then it gives you a second number for what they call a survivor's benefit. And it'll be much less. It'll be like, I don't know, 400 grand maybe, let's say. And it goes on your ex's, on the opposing party's side of the ledger. Okay. Because it's just the way they do it. So it's an interesting setup, and you have to explain to your client, well, your ex has this pension, it's in pay. and it's worth 1.5 million. But you also have now, because it's in pay, you have to declare that you have a survivor benefit, which also has a family law value, and it's going to go on your side of the calculation. Um, and some people don't understand that the survivor benefit, it does have a value because if God forbid the pension holder dies, then your amount goes up. Usually it like doubles. So that's why it's worth something. But people say, well, it's only worth something if he dies. And I go, yeah, well, I didn't make the rules, you know. But anyway, that that's how that works.
Sometimes it feels like that, hey Bill, where people complain to us about the legislation, and I'm like, only we can change things.
Yeah, you know what? It's right. And like Mark said, though, we'll take care of all this weird stuff, you know, so you don't have to worry about it. But that's how kind of how it works, right, guys?
So
Did what I say make any sense?
you do. The impetus of the survivor benefit comes from when the spouse retired during the marriage, at which time 2 months roughly, at least two of the first day months, which sounds complicated, 2 months before the retirement, they would have completed paperwork. Presumptively 60-40%, but the pension administrator will not pay out the pension until said paperwork is completed, during which or at which the pension member elects whether to leave any survivor benefit. Could be 70-30, could be 60-40, could be there's a dozen different options of what could be elected.
Yeah,
If
I forgot to mention that part. You have to assign this, the pension holder has to assign the survivor's benefit. And usually they did that a long time ago when the marriage was good.
and the one
But
spouse
what you're
wasn't
saying is
pension
if they know it's going to break up, they can make trouble.
could.
Yeah.
The other point on for Ontario regulated pensions, yes, there's survivor benefit hinged as of the pension members' employment retirement status as of separation. For federal pensions, there may be a survivor benefit as at the time of retirement, but after separation, if the federal pension member divorces that spouse and marries, the uh, applicable spouse of the pension member would lose the survivor benefit.
Yeah, you know what? It's thank God you're here, Mark, because you can worry about that stuff. I don't, I do some pensions. I usually do parenting cases, you know, which is a totally different thing. It's weird that family lawyers need to know about all this stuff, everything from domestic violence to this. Like it covers everything. And thank
Everything.
God you're here. So for all the folks listening, don't even try to understand it.
No,
Mark
I mean
understands it.
we definitely wear a lot of hats.
Yeah.
But speaking about survivor benefits, I think unfortunately it's sort of a great segue to for Mark to expand um, how this impacts retirement planning. So maybe Mark, you can speak to that a little bit.
Yes, it could mean working longer for the pension member. It could mean saving more aggressively for either of the spouses, in particular, if the pension member who had been on track for 30 and out or certain period of time for employment years of service and lost, as Bill had said, half of a ton is a lot for it. There'll be a big impact on retirement. Of course, it could mean adjusting on any travel, lifestyle, standard of living, adjusting your outgoing expenses. How do you know how much? That is a very good question. That's what the actuaries are for. They can help with the numbers, provided that we counsel supplies them with the appropriate documentation that they need to get the advice, professional advice back to the client. The impact on retirement could also impact if you're close to the clawback on old age security, for example, and you were planning on receiving OAS at what, $6,000 or $7,000, I think it is roughly. There is a clawback. I think it's rough. It was at one point about 150 and 120, at which point you get no OAS. It could shift you to receive OAS. It could shift you to not receive OAS if you're the pension, if you're the spouse of the pension member receiving the pension benefits and your income was say 110, you were going to receive some OAS. So all of a sudden you're receiving pension benefits. You may no longer receive old age security. Um, well, bottom line, if you're receiving half of a ton or a portion of a ton, it's going to impact in a positive way for your retirement planning. And if you're losing that, then it's going to hinder your retirement planning, in which case adjustments are needed, which could entail further discussions or conferring with financial professionals and so on. Um, that's what I have on the impact of
No,
retirement planning.
you've covered everything, Mark. Thank you so much. And I mean, that sort of also ties in with another common question that we get from clients, and I'm sure both Mark and Bill get these questions as well. Is like, well, how do I protect my pension rights? And the short answer is it depends. And it also depends on at what point or at what stage you are in terms of your relationship, which again is primarily how we default as to how to best protect your pension rights. But first and foremost, whether it's done pre-separation, post-separation, pre-marriage, post-marriage, whether we even begin to have that conversation, it all starts with getting the proper disclosure. That's 1A. And this, in my opinion, I think Bill and Mark will both agree, is probably the single most important step, is that we're actually requesting the statement of family law value. And this really ensures that both spouses have, what I like to call an authoritative figure to work with. And this is because pension statements alone, as we've previously reiterated on today's webinar, are not enough because they don't separate pre-marriage or post-marriage, or sorry, excuse me, pre-marriage or post-separation values, right? That's extremely important.
And they
So
also, Joe, they also don't, it's not an actuarial calculation, is it? Like there's no like life expectancy assumptions and all the stuff actuaries do on the
I think they're
statement.
full federals on the statement, 100% on the statement. I know like the way the federal pensions are calculated are different, and they actually do base life expectancy versus men versus women, and that actually changes the family law value. But you're right, it doesn't really consider that. And what I can say again, if we're having this discussion in that you're about to get married in 8 months and you want to know how to protect your pension moving forward by way of a prenuptial agreement, which is a pre-marriage contract, whether we're doing it, post-marriage, what's called a post-nuptial agreement, or if, for whatever reason your mind never turned to it originally, you don't have a prenup or you don't have a post-up, and now we're dealing with it in a separation agreement. Um, Irregardless, all types of agreements should spell out exactly how the pension is being treated, whether that's equalized by payment, or offset, or divided by transfer, or it's entirely protected if we're dealing with a prenuptial or postnuptial agreement. These types of contracts allow us to deviate within reason from the Family Law Act, which is how we guide domestic contracts in Ontario. And there are ways to protect your interests and in relation to the pension from equalization. We're not going to focus too much on that conversation today. It's just more so that it can be done. But the agreement, again, whether it's a prenup, post-up, or separation agreement, should reference the specific legislation as well as the family law value. And I would also make it a priority to ensure that the family law value of your pension is an appendix or a schedule to your financial statement, so that sometimes what lawyers do, they'll prepare what's called a disclosure brief, and that disclosure brief will accompany the financial statement. Sometimes they don't have a fulsome disclosure brief, but the values have or statements have been exchanged between the parties. But generally, I like to include the family law value of the pension in a disclosure brief that actually accompanies the financial statement. And what I like,
As
sorry, go ahead, Mark.
sorry,
Very good. What I also like to tell clients, it's really, really important to avoid. I would say there's three common pitfalls with agreements. The first being double counting or double dipping. So, for example, a spouse transfers part of their pension, plus they give up other assets, but they don't realize that the pension value has already been accounted for. Or, for example, another way that double dipping may become affected is if a pension is in play, or is not in play, is in pay. So they're also receiving, they're also including the family law value of the pension, but they're also including the monthly annuity payments that they're receiving as income. So we have to be careful that we're not double dipping and that we're keeping how I like to see it as pension as property as opposed to income. Um, Another one is just omitting pensions entirely or leaving them out altogether. And that's usually the case if one spouse is either self-represented or they assume that it's not property and they don't even it doesn't come across their mind to include it in their financial statement. That's again a big no-no. Material disclosure is required under the Family Law Act when crafting, negotiating, and finalizing domestic contracts, whether that again is a prenup, post-nup separation agreement. And again, we talk about it in terms of again mixing up support and property. I think those are two topics, even for lawyers. Those often get mixed up and blurred. Again, as previously reiterated, pensions are divided as property. They are not treated as income for equalization, and the income from pensions is relevant to spousal and child support. But again, that's entirely a separate calculation. We don't deal with that in terms of the family law value, in terms of support.
Hey,
And
Joe, can I just jump in real quick?
yeah, please go ahead.
Um, I don't know if you've ever had a client who says, "Oh, I don't care. He can keep his pension." And you go, "Yeah, well,
Um,
whoa, whoa. Let's get the family law value of that thing first, and then once you see how much it's worth, then you might change your mind."
hmm No, 100%, 100%. And, I did receive a couple questions. They've populated. A lot of them are very fact specific. And again, we don't address factual specific questions on this webinar. However, there was a question in relation to CPP payments. So I'm just going to very briefly discuss that here real quickly. Um, in Ontario, other provinces are different. Other provinces have their own legislation, but in Ontario, you are not able to contract out of the division of CPP payments. You are not allowed to say that party A or spouse A cannot seek to divide CPP payments. All right, you're not
What, but
allowed to
what
do
you can do is don't mention it and hope they don't think to do it.
that. Yeah. Yes, but what I'm getting at is that while you cannot contract out of the division of CPP payments, you are able to actually go ahead and do so, and it is done on an uncontested basis. You just have to fill out the necessary forms. But in terms of CPP payments, the spouse is entitled to a division of those. And sorry, and I'm just gonna backtrack in terms of making sure that we are protecting your pension rights. And again, we've discussed it as well on this show already, but it's really important that you consider the tax impact. Equalization payments are generally tax neutral, but the pensions themselves are taxable when they're eventually paid out. That's really, really important. And sometimes, again, we've said it, but sometimes it makes more sense to offset with other assets. So, for example, you give the house equity, like your share of the house equity or RRSPs to avoid triggering pension transfers. And as always, us as your family lawyers, we do have knowledge on pensions. We do have knowledge on how those are to be divided. However, professional tax advice is often wise. We're trained to provide legal advice, not financial advice. Most lawyers will not provide financial advice or tax law, especially if they're not comfortable doing so. Most lawyers stick within the family law realm. Again, others may practice criminal law, they may practice estate litigation, but your lawyer will advise you whether or not they should be providing you with independent legal advice as relates to tax law and your tax consequences associated with making certain financial decisions. So more often than not, it's very important for you to seek professional tax advice in relation to making these decisions. And it's important to consider the tax impact. And number five, again, dealing with both survivor benefits and beneficiary rights. Even if you separate, your spouse may still be the default survivor beneficiary until the divorce is finalized. So it's very important to update beneficiary designations promptly. Otherwise, an ex-spouse could unintentionally inherit survivor benefits, which, if it is your ex, likely you don't want that occurring.
Uh,
As Bill's, sorry, go ahead, Mark.
On the point about the agreement, as
Yep.
a rule of thumb, anytime the pension is federal or extra-provincial or out of the Ontario regime, I usually forward a copy of the draft agreement. This is particularly keen for family lawyers would know this on all of the Air Canada cases that are reported concerning Air Canada pensions. I usually forward a copy of the draft agreement, and I have done that for a long time in my practice, where you come to terms, you come to an agreement, you forward a copy of the draft agreement to the federal administrator or the extra provincial administrator to get their take, because that their jurisdiction might be different than the Ontario jurisdiction, so they might be able to operating on a different perspective than how the division should work. So before signing off, it's important to get the administrator on board with what the making sure that they can regurgitate what the intention is. So when they do receive the agreement, they're going to comply and implement the terms as desired by the spouses in that and the agreement that Joseph was referring to.
100%. And Mark, just because you're speaking to this now, it might be a good time to maybe further dive into, working with. I know we've already a lot of these topics we've sort of covered, each one of us, and we may be regurgitating information, but again, it's very important information that we are regurgitating. Can you maybe speak to your prior history again with working with actuaries or other financial experts in relation to ensuring that these pensions are appropriately and accurately dealt with?
Yes. So an actuary will value the pension. They can project future cash flows. They operate, there is a professional standard guideline that they use in terms of the actuarial assumptions that they are guided by, and they disclose those assumptions within the statement of family law value that is sent by the pension administrator in response to the application for a statement of family law value. An accountant would come in handy to guide on the tax rates to use. We've talked about the pension as an asset value. We've also talked about it having some tax implications in addition to it entering the pension value into the net family property statement. Family lawyers will also enter a contingent disposition or notional tax disposition into the net family property statement. And if there's dispute on that, an actuary is qualified because they can project future cash stream. They are qualified to provide tax guidance, or it could work with an accountant to get the tax information. Accountants oftentimes may be inclined to use a marginal tax rate. It's really important to use the legally recognized tax rate, not necessarily the marginal tax rate. A certified divorce financial analyst can take a lot of the different scenarios that we've talked about here today and present different models and options and scenarios for both the spouse who's in line to receive an equalization or could include pension, or the pension member to work with either of those spouses for purposes of giving some guidance on what different scenarios. Take all of the scenarios that we've talked about. They're all in play. How do we know which one would be ideal? That's where a certified divorce financial analysis really thrives and can bring shine a lot of light on this complex area.
Can I just jump
Uh,
in real quick, Mark? You reminded me of something. Um, I was talking to an actuary. I had a case where the pension was in pay. So the choice was my client could, the other party had enough money to pay it off and keep his pension intact if he wanted to. And he was kind of easy. He didn't really care which he did. So my client's options were you can take some cash now and leave his pension intact, and you'll get like 500 grand in your pocket today. Or you can not do that and let the pension be divided every month um, until, forever. And if he dies, it even gets more, right? And this actuary said, well, it's an interesting issue because if you have 500 grand now in your pocket, and let's say you're 60, um, the chances of you blowing that money and then not having enough when you retire are very, very good. Whereas if you don't take the cash and just leave it as a monthly check every month, it might not be as attractive now. But 20 years from now, you'll be glad you did. And the cool thing is, if it's a big company pension, this is where the defined benefit becomes really, really important. They have to pay that check every month, the pension fund, regardless of whether they've done well in the stock market or not, because they invest in the stock market too, right? The pension people. So it doesn't matter how bad they do, you still get that check every month for life. Whereas if you take the 500 grand now, it looks great, but then you could easily either blow it, spend it, or invest it badly. And God knows a lot of us have lost money in mutual funds in the stock market. And then you're like, you know what? There's a lot to be said for having that monthly check guaranteed, and all the risk is on the pension fund. So that was yet another issue to deal with. I forget what my client chose to do in the end. I think they went for the monthly check.
That was going to be my next point.
Sorry, I stole
On
your thunder, man.
No, no, I didn't mean
Mark, you
that
might as
on
well just
that
go
one.
into common disputes.
Um, on
I was
the
trying to show off my intense knowledge,
Yeah, you
and I just wrecked it for everybody else. I'm sorry.
you cut Mark off his game.
Sorry,
on
man.
on the role of experts, what Bill had shared is really good illustration of working with experts who can help look at things in the big picture. And for the financial analysis that can help with that, making those decisions, do I want money now? Do I want money later? It doesn't have to be the actuary. Spouses can go 50-50 on one neutral expert to help with that guidance. Um, but it's good. It's a good illustration to drive home the point that there is a very important there are important decisions to be made. Common disputes that can arise on pensions in the divorce process. Um, you've heard one, which is what portion of the pension relates to the marriage, because we've heard the possibility that there might be a dispute on separation. Another one could be inflation or indexing. Really uh, um, fine points that you might find in a pension benefits booklet that really we don't ever really read. We leave that for the actuary. Um,
I read
that's
one time, Mark, when I had insomnia, and it totally worked.
that's if an actuary is involved, they're responsible to obtain all of the documentation, including the pension benefits booklet and whatnot. that'll give the guidance with respect to inflation investing, indexing, um, common dispute. Also, we've been talking about here this afternoon, should there be a pension division or should there be a lump sum payment? I did want to mention there's a 50% rule within the Pension Benefits Act, which basically shelter the maximum transferable amount of pension benefits is 50%. There is a section in the Family Law Act where while both spouses are working and the pension is basically an active pension, there can be a request by either of the spouses to have the pension itself divided by installments, which is a unique section that came in just a few years ago and amended to be added into the Family Law Act. Um, Tax impacts, as I've mentioned, um, whether it's average, marginal, somewhere in between in terms of how much to deduct for contingent disposition costs from the value to make sure that we arrive at the net value. And um, these and the other complex areas are all reasons why we'd want to engage professionals to help guide spouses through the division of the pension.
Can I just point out something to confuse everyone?
Go ahead, Bill.
Everything that's been said so far is true and accurate. And if you can actually go, if you can't figure it out in a way by agreement along the lines of what we've been discussing, and Mark, you probably know more about this than I do, you can go to court, and there's a bunch of case law where basically they don't want one person to wind up with just cash and the other person to wind up with just a pension because they have no cash and the other person's going to blow it all. And when they retire, they're going to be in trouble. So there's a bunch of case law. They try to balance that out. Like if it goes to court, and there's ways of doing that, but that's something that hopefully the people out there listening will never, ever, ever have happen to them. But it does happen. And again, the whole point of that is they don't want one person to have no cash and the other person to have all pension. It just, they don't think it's fair. Anyway, have you ever run into that, Mark?
Yes.
Do not talk about it. You're gonna freak me out. No, go ahead, man. Well, how ugly was it?
Made a request on behalf of a pension holder who was actively employed at the time where 90% of his net family property value was from having a pension. I think the parenting was close to shared, arguing that there should be a sharing of the net dollars that you're referring to. And that I think was about a year or two after the amendments to the Family Law Act. And the justice who I was in front of, who I respect immensely, um, wouldn't accept the argument. It might have been too new too soon to when the amendments. I think at that time there was about 10 cases on that area in Ontario in existence, and I'm not sure if it's further unfolded or evolved since, but
You don't want to, for all the people out there, you don't want to go into pension litigation. You can help it.
100%.
And if you do,
Oh, sorry, go
Mark's your
ahead.
man.
Yeah, Mark Simpson, definitely your man at Russell Alexander. And does anyone have any final comments before we wrap up today's chat? Anyone want to give a final
Yeah,
comment?
I hear you can retire quite cheaply in Thailand.
I
my
That's what I had to counsel my client. Dude, just go to Phuket, man. Like it's over. I'm kidding, but it's tempting.
my wrap up would be for what we've talked about. is primarily focused on pensions that are regulated by the pension administrator. Those are pensions that either the employee and or the employer are contributing to. Could be one or the other, could be both. Um, have not really touched upon where there's personal savings going into a savings account that's referred to as a pension one day. And we've kind of segregated the CPP, and it's under the federal act that not just in Ontario, but under the federal CPP Act that across Canada uh, voids any attempted agreements to contract out of the CPP division.
I believe there are a couple. I think Alberta allows you to contract out of CPP division. I think
Really?
there's three provinces. I want to say it's
But we don't
Alberta.
talk about them.
We don't, but I think Alberta, Saskatchewan. No, I can't remember the three, but there's three provinces that actually allow you to contract out of the CPP division. I can't remember off the top of my head, but I know Ontario for a fact is not one of them. And despite lawyers wanting to incorporate those clauses into a separation agreement, it's not valid. They can't do that. There's legislation, but I mean they try.
Hmm. If that section is in there must be something more to the section that invalidates it is under the CPP Act. There must be something more.
I think you have to live on one of those communes where they think they have their own little country. Wasn't there one of those in Saskatchewan? It's a cult.
Sorry, so it's confirmed. Um, Quebec, Saskatchewan, British Columbia, and Alberta.
You're just making this up as you go
No,
along.
no. So those are the four provinces that allow you to contract out of the CPP splitting. So again,
Well,
Ontario.
don't move there.
No, Ontario is not one of them, so you cannot contract out. In terms of my
Hmm.
final thoughts, or unless no, everyone's okay with that. Mark, Mark looks disgruntled about it.
I'm okay with that. I'm
Yeah,
just
we're okay
teasing,
with
buddy.
that.
I'm teasing.
Amazing. With that, thank you, our viewers, both on Zoom and YouTube, for tuning into Family Law Now after hours. Following this session, if you are joining us by Zoom today, a brief survey will appear, allowing you to share your comments and suggestions for future topics that you'd like us to explore. And as always, your feedback is greatly, greatly appreciated. Um, and again, because you have stayed till the end, you are able to book now to take advantage of this opportunity for a complimentary 20-minute consultation with one of our lawyers here at Russell Alexander. And in order to do so, please contact our intake department at intake@russellalexander.com and mention our after hours series to schedule your appointment. Registration is now open for our next event, which is next Tuesday. Can we really get divorced without going to court? Short answer, no.
Well, you can't get
Through
a divorce, but
documentation. Through documentation. That's the only way. But yes, technically, you can get divorced without going to court. There's a lot of forms, but they will expand on that next week. All you have to do is just go to russellalexander.com // family law now. Thank you again to our panelists, both Bill and Mark, for sharing their insights today, such knowledgeable individuals. And thank you, our viewers, for tuning into Family Law Now after hours. Have a great evening and see you at the next.